Bismillahirrahmanirrahim. In continuity of the last question, the historical school of thought, they advocates that the international law is a proper and true law, and they supported their arguments with the following points. According to them, international conventions and conferences are the main source of international law, and the international law is resulted from those conferences and conventions and treaties. They also placed on record that there is no denial by the states. The existence, the existence of international law is accepted by the states as subjects, and no state denies the presence of international law. Recognition of international law. They also advocates that international law is a proper law because the same has been recognized by the UNO, its subjects, and the other international forms, uh, forms and forums. Violation does not mean no presence of law. This argument is also valid because generally the state laws also has been violated regularly, but no one can deny, no person can deny there is no law. There is rules about traffic signals, about the respect of human dignity, but the traffic signals are violated, humans are tortured, but it doesn't mean there is no state law. Such like international law is a proper law according to the historian school of law. Sanction behind the breach of international law. They were of the view that there are sanctions. It does not completely lack it pressure of public opinion, criticism, and penalties provided in the treaties are the sanctions behind the breach of international law. International law is a part of state laws. They also advocate that certain countries, indeed in practice, expressly treat the international law as possessing the same force as the ordinary law binding their citizens. In charming Betsy case, Chief Justice Marshall of American Supreme Court declared that an act of Congress ought never to be construed to violate the law of nations if any other possible construction remains. The same type of the arguments were in Paquet Habana case. Justice Gray remarked that international law is a part of our law and must be ascertained and administered by the courts of justice. Decisions of the international courts of justice, the decisions of ICJ and their binding force and their acceptance is also one among the evidences that the international law is proper law. Way forwards for improvement of international law. The researchers and professors of international law have submitted certain way forwards, such as they were of the view that the General Assembly of UNO would be given authority to regulate and to produce law about states and the other subjects of international law. Rule making and law giving treaties, and they also of the view that like a general treaties there should be a rule making and law binding treaties among the states, between the multinational companies and INGOs. uh, Codification of international law. They also presented that for the betterment and to give a binding force, the treaties and other rules and conventions should be in a codified and written form. Strengthening of international law commission. It is also regularly advocated that the international law commission should be supported and strengthened to give a due weightage to the international law. International police, there is also a good idea about the like a blue helmet type about international law police. Establishment of investigation and independent prosecution system, like a system of prosecution in states and in developed communities. These same like systems should also be provided under the umbrella of international law. International criminal court. It is necessary that international crime that the international crime should be tra- trialed and adjudicated by an effective and independent criminal court, compulsory jurisdiction of international court, and it is also a valid argument and a brightening way forward for to give a binding force to the international law that the jurisdiction of the ICJ should be compulsory, should be binding, not to the will and acceptance of the states. Judicial precedents like a state law, the celebrated and classical decisions of the ICJ and the other international forums should also be given the status of precedent, good relations among the states. Last but not least, for the betterment and good governance and to give a due weightage to the international law and regulation of relations between states, the relations between states must be based on brotherhood and development of good relations among the states should be promoted for betterment, for better enforcement of international law. Thank you very much.